Hello, I'm Nikki Jovicic from LookUpStrata and welcome to another episode of our Strata Snapshot series. I'm here in Brisbane with Mario Esera, Senior Associate at Piper Alderman. Mario, welcome.
Hi Nikki.
I wanted to spend a few minutes with you today discussing termination of management rights agreements in Queensland. I believe this is a topic you're particularly interested in. Would you like to tell us why you have an interest in this topic?
Sure. Well, I've acted for both sides. So I've acted for bodies corporate and I've also acted for management rights holders. In recent years, however, I've exclusively acted for bodies corporate. And one of the things that I've learned from that time is that terminating these agreements is extraordinarily difficult. I'd go so far as to say that climbing Mount Everest might be easier than terminating a management rights agreement. Why? Well, with climbing Mount Everest, you know how long it's going to take, you know roughly how much it's going to cost, and you know that about 4,000 people before you have done it successfully. Unfortunately, the same cannot be said for terminating management rights agreements.
What do you feel should be done to prevent these difficulties in the future?
Well, I think the difficulties primarily stem from the legislation and how the legislation has actually been applied. So the legislation that I'm talking about is the Body Corporate and Community Management Act. On the face of it, the act of terminating a management rights agreement shouldn't be too difficult. You effectively issue a remedial action notice. If that notice isn't complied with within the required time, you then call an extraordinary general meeting, and if at that extraordinary general meeting a decision is made to terminate the management rights agreement, it has to be done by way of an ordinary resolution and by way of secret ballot. Unfortunately, in practice, each of those steps contains a variety of pitfalls that bodies corporate can fall into. There can be questions about the remedial action notices themselves, whether or not they comply with the formal requirements. There can be arguments about whether or not the remedial action notice is actually being complied with. So you can have an argument, for example, where if you say you haven't cleaned a particular area, part of that area is cleaned and the other part hasn't, does that mean that the notice has or has not been complied with? Finally comes the termination itself, approval at a general meeting. There can be a variety of arguments about whether or not the termination motion has been drafted correctly, whether or not it's been approved correctly, that is by way of an ordinary resolution, and there can even be arguments about the ballot itself. Finally, if the body corporate gets through all of those procedural hurdles, they then are faced with the difficulty of satisfying potentially the Office of the Commissioner that their decision to terminate is actually a reasonable one. And that really is like the last and sometimes the most difficult hurdle for bodies corporate to actually overcome.
Okay. Mario, are you able to give some examples of some of those difficulties?
Sure. Probably the two examples that come to mind, one relates to remedial action notices themselves, and then the other one relates to this issue of reasonableness. There was a case that came out recently that I wrote a newsletter on, which was the body corporate for Rots Resorts. Unfortunately for the body corporate in that case, they encountered a difficulty when it came to the actual drafting of their remedial action notice. In short, what the legislation says is that the time to comply with that notice has to be not less than 14 days. The body corporate for Rots Resorts issued a variety of remedial action notices, and in those notices they had the phrase within 14 days instead. They went through a lengthy process of litigation to effectively arrive at a point where they were informed that because they'd used the wrong words in their remedial action notices, that all of those other steps that they took afterwards were invalid and of no effect. So you had, like I said, a very unfortunate situation for that scheme where they undoubtedly spent many hundreds of thousands of dollars to get to a point where all the steps that they'd taken to terminate the engagement of their caretaker and leading agent were thrown out, and they were effectively back to square one after who knows how many months, possibly years. The other example was this one of reasonableness, and like I said, that's probably the most important one for all bodies corporate. That is the breach notice that you've issued for a breach that is reasonably serious enough to warrant terminating their engagement? Now that's not what the legislation necessarily says it requires in terms of remedial action notices, but this overarching duty to act reasonably is one that is effectively the last hurdle that must be overcome. There was a case that was decided, I believe, at around August of last year, concerning Trojan Resorts, and that was another case where you had a scheme that believed that they had sufficient grounds to terminate an engagement. It concerned resignation of a director. The facts themselves are not important, but what is important is that they failed in their bid to terminate that engagement, ultimately because the grounds that they relied upon were not considered to be reasonable. So coming back to my Mount Everest example, in all my years practicing in this space, I only know of a handful of cases where an engagement has been successfully terminated. One of those cases was actually handled by my supervising partner, and that case was many, many years ago. But I believe that it's a situation where you can probably count on one hand the number of times bodies corporate have done that successfully.
And what do you feel should be done to prevent these difficulties?
Short of changing the legislation, I think that what needs to be done is potentially some greater guidance from the Commissioner's Office. What I think would be really helpful would be if, for example, the Commissioner's Office provided some pro forma remedial action notices, one that had these fundamental requirements in there, and it effectively was one where it was kind of fill in the blanks. I think that the best thing that a body corporate can do is just make sure that they get some very, very good advice as to what steps they need to go through, and then hopefully the people that are advising them, people like myself, are able to assist them. So at least from a procedural point of view, they know that everything's covered. But the bottom line is that there's always going to be that litmus test of reasonableness, and that's something that they should also get some good advice on first. For example, is it reasonable to terminate a management rights agreement because a caretaker has left some cigarette butts outside for many months despite remedial action notices? Yes, that's probably in breach of their agreement, but is it reasonable? Ultimately, that's a decision that may need to be made by an adjudicator for the Commissioner.
Thank you.
No worries.
Would you like to tell us a little bit about Piper Alderman?
So yeah, Piper Alderman is a national firm. We have offices in Sydney, Melbourne, Adelaide, and obviously in Brisbane. And I've been a senior associate here for the last 3 years, just over 3 years.
Okay, thank you very much for your time, Mario. Contact details for Mario and Piper Alderman can be found at the end of this video. Thank you for watching LookUpStrata Snapshot series, and we hope to see you again.